Can you confirm if you're just able to see my screen?
Yes, we can see.
All right. Okay.
Yeah, just you need to, yeah.
All
No,
right.
it's
Okay.
perfectly fine. Yeah.
Okay. Thank you. So the presentation that I'll be making today is on introduction to copyright. We'll discuss the law. We'll discuss some aspects of enforcement and some challenges that are being faced in the copyright world today. We'll do this with the help of some legal provisions and with the help of some case laws, old and new. So, if you see, the first question that comes to mind when you listen to copyright, when you hear the word copyright, is like, what is copyright, right? And copyright is exactly what the word says. It's the right to copy. So, and the owner of the copyright and anyone that's authorized by the owner are the only ones with the right to reproduce any work. So copyright protects the expression of a particular idea, the manner in which it is made. The work has to be an expression. It has to be a combination of things, and copyright does not protect an idea per se, right? You may have an idea. Four people may have the same idea, but if the manner in which the idea is expressed by these four people differs and there is originality in each of the four works, then each of the four works can be protected, even though the idea may more or less be similar and may eventually lead to the same or similar result. Then the next basic point that we need to remember is that copyright is automatically created as soon as the work is created. So if an original copyrightable work is created, then automatically copyright vests in it by virtue of creation, which brings us to the next part, that registration as such of copyright is not mandatory. And while it is definitely recommended because it acts as prima facie evidence of your ownership in the work, and it acts as legal evidence in case of an infringement or in a court case, etc. But it is not a mandatory requirement, and the copyright in a work vests by virtue of its creation automatically. So next, we'll look at what is the legal framework for copyright in India. So it is governed by the Copyright Act of 1957, which was last substantially amended in 2012. It is administered by the Copyright Office. That is, if you seek registration, then it is the Copyright Office that administers that, which comes under the Ministry of Commerce and Industry. India is a signatory to, with respect to copyright specifically, India is a signatory to major international treaties. There are several others, but these are the two main ones in my view. One is TRIPS, which is Trade Related Aspects of Intellectual Property Rights Agreement, and the second is the Berne Convention for Protection of Literary and Artistic Works. Uh, TRIPS is both of these treaties actually set the minimum standard for IP protection for its member nations. TRIPS is it relates to IP in general, and while there are specific chapters for different kinds of IP, Berne Convention is specific to copyright. In fact, it says that if a particular work is protected in a country, is protected in say one country, then it will be protected in another member nation as if it were a domestic work there. Now, for example, if both Canada and India are signatories to the Berne Convention, if a work is protected in Canada, then by virtue of its protection in Canada, it automatically gets protection in India as if it were an Indian work. It gets as if it were a domestic Indian work. So that's the advantage of being a signatory to the Berne Convention. So this is the principle of national treatment that I just referred to. So, a question arises as to what all can I protect, right? What all can I claim copyright in? So, there are several different kinds of works. The first is the literary work, which is the actual written word, the written text. So books, computer programs. Now, computer programs meaning software can be protected as copyright. It is so you have to give the object and object code and the subject code of the program itself, and that is what is protected. Then you have dramatic works in which choreographic works or plays or screenplays, etc., are protected. Then you have musical works, which are compositions and the notation of a particular work is protected as copyright. Then you have artistic works like paintings or sculptures or photographs or architectural works, etc. Then you have cinematograph films, which are visual recordings. So your movies or your YouTube videos, these short videos, short films, anything that you watch as a video on a visual platform is a cinematograph film. Then you have sound recordings, which are recorded audio songs. These are songs or any other kind of audio as such. Now, what is the who owns these rights, right? So, because there are several different kinds of works, so there can be who are the owners of these works. So, the first rule of copyright that you need to remember is that these are for original works. Now, originality is a big thing in copyright. You can only claim copyright if a work is original. So if in original works, like in first hand owner is the author of the work. Now, author meaning the person who created the work. So in case of literary works, it's the author, that is the creator of the work. Then for dramatic works also is the author. For musical works, it's the composer of the music. For artistic works, it will be the artist. Then for a photograph, it will be the photographer. Now, there are some other kinds of work as well, right? Like derivative works, which include cinematograph films, sound recordings, etc. Now, derivative works are when you use the original works to derive something and make another work out of it. Now, for example, a cinematograph films contain dramatic work, it contains music, it contains a lot of other things. So, a derivative work will be owned by the producer. Then a commissioned work, like if I say commission someone to make a painting for me, there I am the owner of the work because I am the one commissioning it. And then the third part is where work is created in the course of employment. There it is the employer who that's the owner of the work, unless of course there's a contract to the contrary. Okay, so what kind of rights does a copyright owner get? Um there are a bouquet of rights that you get, which broadly can be divided under two heads. One is economic rights, and the second is moral rights. Now, economic rights are fairly straightforward. The right to reproduce a particular work. Say I wrote a book, right? The fact that I want to make 50 copies of the book is a right of mine as a copyright owner. I want to make these 50 copies and distribute them. I want to sell them in a bookshop. So that's my right. Then, and third is I might want to, make enact this out before the public. That's a public performance right that I have. Then I may want to, it's an English book, I may want to translate it into Hindi and, adapt it into a play or adapt it into a movie or something. So that's again an economic right that a copyright owner has. So these are broadly the economic rights, basically the kind of rights that you could generate some kind of compensation or remuneration from. Then you have moral rights. So moral rights are specific to copyright actually, and there are two main kinds of moral rights. One is the right of attribution, also known as the right of paternity. Means that a person will always have the right of a particular work being attributable to them. For example, say Mr. Javed Akhtar writes some lyrics for some song, right? And the lyrics are assigned to the producer who eventually makes, this a song is made, etc., etc. So the copyright in it may not belong to Mr. Akhtar, but he will always be at the fact that he's the one who wrote those lyrics will always be attributed to him. So that is his moral right, the right of attribution. Then there's right to integrity. So as a copyright owner, or as a creator rather, I have the right to integrity, which means that I have the right to object to any kind of defacement or any kind of derogation that is done for against my work. Now, for example, I am a sculptor. I make a sculpture. If someone, or I make a painting, and someone decides to write some filthy language on it, or paint over it, or do something like that, I have the right to object to it. So I have that is the right to integrity. So then we'll talk about duration of copyright for literary, artistic, and musical works. It's the lifetime of the author plus 60 years. So say I created a work at 50 and at 20, and I live for another 50 years. So that's 30 plus 60 years. So it's my lifetime plus 60 years. Then for films, sound recordings, and photographs, it's 60 years from the date of publication. Now, for example, if a movie released on, say, 1st January 2020, then the copyright in it will vest till 1st January 2060. Not 60, sorry. If it released on 1st January 2000, then it will vest till 1st January 2060. Now, what happens after a work, the duration of copyright expires? Once the copyright expires, it moves into public domain, and then it can be used by anybody. Now, in fact, interestingly, at some one point, the song, which the most popular song in the world that we sing almost every day is Happy Birthday to You. Now, Happy Birthday to You was at one point a subject matter of copyright, and its heirs decided to file a suit, and there was a case decided in the US in 2015 in which the court finally said that no, now it's in the public domain, so you can't really seek a license for its use. Um, so yeah, it goes into public domain after the expiry of the copyright in it. Now we'll discuss a few principles that form the basic tenets of copyright in India, and these tenets were evolved through case law. We'll discuss two of them. One is the idea expression dichotomy, which was discussed by the Supreme Court in the case of R.G. Anand versus Deluxe Films and others. Like we discussed earlier, no copyright exists in an idea, right? It is the expression, the original expression of an idea that can be protected as copyright. So the protection in any work is confined to the form, the manner, the arrangement, and the expression of the idea. So what happened in this case was that Mr. Anand claimed that Deluxe Films had copied the idea of one of his plays called Hum Hindustani, and Deluxe Film made a movie called New Delhi, and he said that it was infringement of his copyright in the play. So the court looked at the facts, etc., and then maybe the basic idea, maybe there may be some sort of similarity in it, but there were enough differences. And in this case, the court laid down certain principles and categorically said that it is not the idea, but the expression of an idea that is protected under copyright. So if you read like we've written here, it is the original expression of thought or information in some concrete form that is protectable subject matter under the act, and not merely an original thought or information per se. In this case, the court also talked about how do you make out whether a work is original, whether there is any sort of infringement that's happened from a previous work. Now, are there substantial similarities in the works? If I view a particular movie, sometimes it happens, you watch something and you're like, oh yeah, it was similar, but would you necessarily, will the subsequent work Bring the initial work into your mind. That is the test. Will you think that yes, there is a, it has been copied, it's the same thing? When there may be a lot of stories which may have similar ideas, but it is the expression of the idea that is important, and that was what was held by the Supreme Court in RG Anand versus Deluxe Films. Now the second case that is again a landmark case in copyright in India is the case of the Eastern Book Company versus DB Modak, which was again a Supreme Court case in 2008. So, in this, what happened was EBC is Eastern Book Company. It publishes a compilation of Supreme Court cases called SCC. It adds features like formatting, cross referencing, page numbering, case notes, etc., to make it more user friendly. And so EBC claimed that Mr. Modak's company, that is the respondent, had copied their module SCC and converted it into CDs, and they were distributing these CDs to the public. So, based on this, EBC claimed that their copyright was being infringed. Then the respondent argued that EBC's publication lacked originality because it was only a derivative work from the judgments. The judgments were in the public domain. They didn't do anything to it. They were just compiling these judgments together. And so there was no originality in their work, and hence it is ineligible for protection. Um, Now, here, like we've discussed several times already, the work needs to be original. So, what is the law around it? The law is that the subsequent work, the work which comes into being, should be original in the sense that by virtue of selection, coordination, arrangement, etc., of pre existing data contained in a work is somewhat different in character than the original work, right? So you may make additions to it, you may compile it in a certain manner. Whatever it is that you do, the work that is generated must be different and original in its own right. So, what the court had to look into was whether EBC's efforts had transformed the original judgments that were in the public domain sufficiently to make them original works in their own right. Now, here the court, there was a difference in there are two tests that the court looked into. One is the sweat of the brow test, which basically says that if you put in effort and if you put in a lot of hard work into something, and you expend your skill, etc., is enough for it to make something copyright protected. This is the sweat of the brow test principle, not test. And then from here, the court went to the modicum of creativity principle, which is that while you may put in effort, while you may put in a lot of hard work to create something, it also needs to involve certain intellectual effort and a certain degree of creativity. It can't just be that I've put in effort, so this is copyright protected. Now, this also flows from the fact that a work needs to be original, right, and substantially or at least significantly different from the original work, from the first work. So, which is why a certain degree of creativity is required to be put. So, this is the modicum of creativity principle that the court applied, and said that even though the underlying material, which is the judgments, are in public domain, the work that was put into by EBC in editing, arranging, formatting these judgments, etc., are protectable as they meet the threshold of creativity that is required. So these are the two main cases, one of two landmark cases in copyright law, and a lot of the cases that are decided in India are based out of these two. Now let's come to infringement violation of copyright. So when does someone's copyright get infringed, right? So in simple terms, what is infringement? Copying, distributing, or performing anybody's copyrighted work without their permission is infringement. It can happen in two ways. It can either be direct or indirect. Now, what is direct infringement? Is that if, say, I am the copyright holder and I have the exclusive right, if you do something that is my right exclusively and I have not authorized it, then it is a direct infringement. So, if a person does anything which is the exclusive right of the copyright holder as conferred under the Act, then it is a direct infringement. Then there could be an indirect infringement, in which if a person uh, allows, for profit, allows use of any place for communication of a work to the public, decides, post a movie or a work that is copyright protected, and they know that it is an infringement, but they allow it to be hosted on their website, then it amounts to indirect infringement. Them allowing the hosting of this work on their website would be an infringement. That is an exception to indirect infringement. Then there are other acts as well that can be considered to be infringement. One is distribution of infringing copies for the purpose of trade, to an extent that it affects the copyright owner prejudicially, or importing an infringing copy. Now, this is not just one copy. One copy can be for private use,
Hello, ma'am.
which is an exception.
Sorry to
Yeah.
interrupt. I think your
Yes.
slide is not visible right now. Could you please reshare it?
Okay.
Yeah, and your
Yes.
voice
Yes.
was also breaking in between.
Oh, okay. Are you able to see it now?
Not yet. Yeah, now we can see it. Yeah.
Yeah.
Yes, yes.
Do you want me to repeat a slide? Which slide were we on? I mean, we were
No,
on
no, you
this,
can.
but
Yeah, you can carry on. We were on this slide only.
all right. Okay.
Yeah.
Oh, sorry. Yeah. So importing of an infringing copy, not one copy, but for if there are several, then even that could amount to infringement. Now, there are some statutory exceptions. These are statutory defenses that are provided for under the Act, defenses to infringement. Um, there are several. We've put in some key items here. Now, fair use is the biggest defense that is available, that my use of the copyright was fair dealing. That is, it was for either for private use or for research or for satire or criticism or for review of a work, or for reporting of current events. Basically, if my use amounts to me being the infringing party, if my use amounts to fair use under the Act, then it is a defense against infringement. Or if there is transient or incidental storage, means if it was only being stored or communicated for a very short while, or if it just happened to happen, because not because it was an intentionally done thing, then it is transient or incidental storage. Then if it is for reporting of a judicial proceeding, or if someone reads out or recites excerpts of a published work in public, or if there is reproduction by teachers or by students during instructions, or if there is a report in the newspaper of a lecture that has already been published, so the report or a review in the newspaper, performance by a non-paying a performance of by an amateur to a non-paying audience. Now tomorrow if I decide to go and sing on stage, I've no the song I'm singing, the owner of that song can't come and sue me for infringement, because if as long as it's a non-paying audience or for the benefit of a religious institution, or storing of the work in a non-commercial library, making copies of a book by a non-commercial library if the book is not available in India. Now if you see, a lot of it is also if I'm deriving commercial benefit out of it. If as long as I'm not deriving commercial benefit out of it, it could be a statutory exception. Of course that's not a hard and fast rule, but broadly that's what it could be said that that is how it works. Now, those are statutory defenses that are provided for under the Act. Now, there are some common law defenses that have been, because India is a common law country and we don't just follow the letter of the law as provided in an act, but courts in India also evolve the law and they also make law. So these are common law defenses, that this is a common law defense that has been laid down by courts in India. So this is premised on a legal maxim called de minimis non curat lex, which translates to the law does not concern itself with trifles. Now, trifles meaning like small, insignificant issues. So the applicability is that very minor or insignificant uses of copyrighted material will not be actionable or may not be actionable, because the law will not typically scrutinize or act against copyright violations that are too trivial, too small to warrant any kind of legal intervention. So this is another defense that a party may make, that my use was very, very minimal and it's barely even there. So it falls under this maxim and hence is not actionable. Then we'll come to what are the civil remedies that are provided for. First is who can be the plaintiff. If I decide to sue someone, then who can be the plaintiff? One is the owner of the copyright or their exclusive licensee, not a non-exclusive licensee. An exclusive licensee that only, other than the owner, only I have the right to use it. So only these can be the plaintiffs. Reliefs are injunctions can be issued. Now, injunction is if the infringing party is stopped from carrying out their infringing activities. Then damages, whatever damage I faced because of the infringement, I am eligible to get that money back. Now, costs are discretionary. Costs are basically it's usually done in an exemplary to make set an example. So because somebody was doing something that was illegal, costs are imposed on them in addition to the damages. And delivery of the infringing copies or equipment that is used to produce the infringing material. Now, where the defendant proves that they had no knowledge, this is in the case of indirect infringements, where defendant proves that they had no knowledge or reasonable belief that the work in which they were dealing was copyright protected, only injunction is granted and damages or rendition of account, that is damages, are granted, and the rest need not be granted. That of course depends on the subjective discretion of the court. There are also criminal remedies available, but like is applicable for all criminal matters, the first prerequisite is that there should be intention, mens rea. There is intent to infringe. That is a prerequisite. Now, here the police can search and seize someone's premises and seize copyright infringing copies and plates and equipment, etc., without a warrant, and file a complaint before the first class magistrate. Then punishment can range from 6 months to 3 years of imprisonment, plus a fine of 50,000 to 200,000. Then if it wasn't being done for gain, the infringing activity, then for commercial gain, then there is a discretion on the judge to grant a lesser punishment, but there is also enhanced penalty for second and subsequent infringements, with the minimum imprisonment term becoming 1 year and the fine being 100,000. Now, we'll discuss something that, because this year's WIPO theme is music, I think it's important that we discuss some copyright aspects with regard to music as well. But for that, and we'll discuss a case for that. But let's first talk about copyright societies. Now, what are copyright societies? Copyright societies are societies that are registered under the Act to help owners of copyright grant license, grant licenses for use of their copyright and for ease of the public to seek such a license. Now, for example, if I want to use Kal Ho Na Ho, the song somewhere, uh, I don't know. I know that the song belongs to probably Dharma Productions. I don't know how to approach Dharma Productions to get rights to the song to use it somewhere. And so, what will I do? I will approach a copyright society that owns the song. So, what happens is that copyright owners assign their rights to these societies, who in turn assign, meaning they sell their rights to these copyright owners, sell these rights to the copyright societies, and then these societies grant licenses for on behalf of the copyright owner. Now, the act bans carrying on of business of issuing or granting licenses for copyrighted work except through registered copyright societies. So a body cannot carry on the business of issuing or granting licenses en masse. Like, you cannot make a business out of it for granting these licenses unless you're a copyright registered copyright society under the act. If a copyright society is being managed in a manner that is detrimental to the interests of either the owner, then its registration may be cancelled. And there's a case which said that unlike a registered copyright society, an agent cannot issue licenses in its own name. It can only do it through a copyright society. You have to be a member of a copyright society to be able to do it. So these are a few copyright societies. These are, in fact, the only copyright societies that are registered in India. So if you see, for different kinds of works, there are different societies that are registered. So if you see, the first one is for literary works that are associated with musical works. For example, that's for lyrics of a song. That's IPRS, that's Indian Performing Rights Society Limited. Then for photocopying works, you have Indian Reprographic Rights Organization, IRRO. For singers performance, you have Indian Singers Rights Association. For recorded music performance, you have RMPL, which are for sound recordings for songs. Then for cinematography, for movies, you have Cinephile Producers Performance Limited. That's Cinephile. Now we'll discuss the case which we needed to understand what copyright societies are. And this is a very recent case that's happened earlier this month, in fact, and decided by the Delhi High Court. It's still sub judice, but this is the preliminary interim order that the court has granted. So this is Azure Hospitality versus Phonographic Performance Limited. Let's call it PPL. Azure is a company that operates multiple restaurants all over India, and PPL is a copyright collective that is in the business of issuing licenses for publicly playing songs. Now, PPL is a copyright collective which owns the copyright in lot of from a lot of music record labels, and it issues licenses for the use of these songs in public. PPL was a registered copyright society till 2014. It is not a registered copyright society as of today. It owns public performance rights of 400 plus music labels, which with more than 4 million international and domestic sound recordings. So it's big. It's a big party. Now, PPL filed a suit against Azure for playing songs it owned in 86 of its restaurants without seeking a license. Azure argued that PPL is not a registered copyright society under the Act, and that is why it cannot issue licenses or sue for infringement, which is what the law says. But the single judge of the Delhi High Court held that because these rights were assigned by music labels to PPL through assignment deeds, PPL became the owner, and hence it had the right to license these rights despite not being a copyright society. So PPL could license it as the owner of the work even though it was not a copyright society. Now, Azure filed an appeal before the division bench of the court, and which overruled the order of the single judge. The division bench said that Section 33, which talks about how a company cannot function in the business of issuing licenses, is prospective. Now, it unequivocally prohibits any person from carrying on the business of issuing or granting licenses in respect of any work in which copyright subsists, unless you are registered under Section 33, which is registration as a copyright society. So, under Section 33, only a registered copyright society is permitted to carry out the business of issuing licenses, and PPL cannot issue licenses for public performance because it is not a registered copyright society. PPL made the same argument that the single judge had made in its favor, where it said that, I'm the owner. But the court said that you may be the owner, but you are issuing licenses en masse, and you are in the business of issuing licenses. So, if I were to allow your argument, then the regulatory regime, it becomes redundant. There's no point of having a specific bar on non-registered copyright societies issuing licenses if I were to allow this argument. So, which is why people lost the the interim order before the division bench, and was direct. But because at the end of the day, Azure cannot be allowed to use this music free of charge because it is copyrighted work at the end of the day. So the court ordered Azure to pay PPL for the songs played by it a sum that is charged by RMPL. Now, RMPL you saw earlier was the Registered Copyright Society for sound recordings. So, every copyright society has its own tariff based on which money is paid, a license fee is paid. So, as so the court said that Azure will have to pay PPL along the lines of RMPL's tariff, as if PPL is a member of RMPL, and PPL will not be allowed to use its own tariff. Now, this specific direction has now been stayed by the Supreme Court in an SLP day before yesterday on April 21st. So, not the fact that PPL can't issue licenses, that part still remains. But the direction to make payment based on RMPL tariffs has been stayed by the Supreme Court. And now we'll just wait and watch, and we'll see what happens in the case. This is still ongoing. Now, another burning issue in copyright these days is the challenges that we face because of work that is created by AI and the copyright that vests in it. So, author, what are the main issues that we face? One is that author, in relation to any work, is the person, author in relation to any literary, dramatic, musical, artistic work, etc., which is computer generated, which is generated by a software or by a computer, is the person who created the work. Now, so currently only human beings own copyright in India, right? But when it's AI generated, now for example, if say I ask ChatGPT to create some story for me, I ask it to please write me an essay on copyright in India. So, who owns the copyright in that? Do I own it? Because I put in the question, but I didn't create it. The AI did. So, can I say that I own the copyright? Now, can the AI own copyright at all? It's not a human being. Can AI own copyright because they are the ones who seem to have created it? Or is it OpenAI? OpenAI is the owner of ChatGPT, it's the main company. So, does OpenAI own it? But OpenAI says that they train AI models. So, do they own it? Who owns the copyright if ChatGPT comes up with a story or a composition or whatever? Now, these kind of questions are arising all over the world, including in India in a case, and copyright infringement suits are happening because of this. And because of this, what happens? It becomes difficult to stand out in a crowd with your own creation because it's not what you think from here; it's what the AI is thinking for you. So it could lead to stunted creativity and thinking because you're not thinking on your own. A machine is thinking for you. So, copyright infringement suits. Now, this is a copyright infringement suit that has now been filed before the Delhi High Court by Asian News Network (ANI) versus OpenAI, which is the owner of ChatGPT. This is the first case which discusses copyright issues by AI in India, and it has still not been decided. But it's worth a discussion definitely here because it's the first of its kind, and this is only going to increase in the day and age that we live in, the digital world that we all live in, and with the use of AI in almost every aspect of our work and life these days. This will soon become the norm. So, what happened in ANI versus OpenAI, which was filed before the Delhi High Court in 2024, I think late 2020 network, and they claimed that OpenAI was using copyrighted news content without authorization from ANI to train ChatGPT. It they said it had no right to use its content for profit, even if the material was freely accessible online. It was available everywhere because it's news, right? So it's available, it was freely accessible online, but ANI said OpenAI does not have the right to use it. Then it also said that OpenAI must comply with copyright laws and for AI training, which means basically going around the web and using content that is available without compensation, amounts to commercial exploitation because content creators have the exclusive right to decide how their work is supposed to be used. Based on this, they filed a suit against OpenAI and claimed heavy damages. What does OpenAI have to say in response? OpenAI said that Delhi High Court doesn't have jurisdiction because it is a US based company. It has no physical offices and does not have operational servers